Hi, this is Fred Neiman of Hanlon Neiman, a Central New Jersey law firm practicing zoning and planning law in all 21 counties of the state of New Jersey. Our state, New Jersey, has been one of the leading states in the nation in the creation, adoption, and enforcement of zoning laws. Every town in New Jersey is required under the Municipal Land Use Act to adopt a comprehensive master plan and land use ordinance every 6 years. New Jersey law requires that each municipality have a residential zoning law, a commercial zoning law, an industrial zoning law, open space zoning laws, public use zoning laws, and open space and agricultural zoning laws. These laws and regulations dictate how you can use your property, whether it be, for example, residential or commercial use. Often these ordinances will dictate the minimum and maximum sizes of your property, including building lots. It will define the maximum height of your home or your office building or other commercial structure. For example, limit it to 2 stories or 50 stories. It'll also dictate how close to your neighbor's property line you can build, which is often called a setback distance. If you want relief from the strict enforcement of a municipality zoning ordinance, you must file an appeal to your local Board of Adjustment. That's easier said than done. You have to file an application. You have to give public notice to all individuals and property owners within 200 feet of your property. And you have to give evidence and proof before the Zoning Board of Adjustment as to why you should receive a variance from the local law. Legally, you can't get a variance just because you're a good guy or you're an upstanding citizen. If you need relief from a zoning law or a regulation, you need a variance from your local Board of Adjustment. A local Board of Adjustment consists of between 7 and 9 members. They're all residents of your town or employees or public officials. Boards of Adjustment require that you hold a public hearing for your neighbors and members of the public to participate, to voice their opinions as to whether you're entitled to a variance. The law requires that you produce legal evidence and proof to justify your request for a variance. It's not enough, again, to say, I want a variance, therefore I should be given it, or I'm a good neighbor and pay my taxes on time. If you don't produce the legal proof and evidence necessary for the granting of a variance, your application will be denied. You have to earn it. You have to prove it. And what happens if you have neighbors who object? The town may also not be in favor of your application and may throw in unreasonable demands to your pursuit of a variance from the municipal board. You need to learn such terms as building variances, subdivisions, setback requirements, and terms like conditional use variances and height limitations and C1 and C2 variances, all these various types of variances that are applied for each week in our state. If your neighbors oppose you, you particularly need legal assistance. Many times they hire an attorney to introduce obstacles to your application. You need to contact me. You need an experienced land use and zoning law. Our firm has represented over 20 separate and distinct zoning boards, planning boards, municipalities, agencies, and county authorities. We know zoning law, and we're statewide in our presence. We know how they think, and we know the personalities of many of the boards. Call me today. Call me toll-free at 888-800-7442, or you can email me at fneiman, N-I-E-M-A-N-N, @hnlawfirm.com. Learn your rights. Let Hanlon Neiman represent you and apply our decades of zoning and planning board law to your benefit.